So here's where things get really interesting. Remember all the chaos we've been following around Blake Lively versus Justin Baldoni Wayfarer and all the PR drama attached to this case? Well, the latest legal move could completely change everything. When Blake filed her second amended complaint, Jed Wallace responded with a motion to dismiss. At the time, I pointed out that his filing looked like a roadmap, basically laying out how Wayfarer could also try to get these claims thrown out. And now, Wayfarer has finally stepped in. But instead of going for another motion to dismiss, they've filed what's called a judgment on the pleadings. So what does that mean? Think of it like this. It's very similar to a motion to dismiss, but it happens a little later in the process. Once all the pleadings are closed, meaning the defendant has already filed their official response, the defendant can ask the judge to look strictly at the written complaint, the answer, and any attached exhibits. No new evidence. No discovery. Just the four corners of what's been filed. Wayfarer is essentially saying, Judge, even if everything Blake says is true, her claims still don't hold up under the law. That's the big difference here. It's not about disputing facts. It's about saying the law doesn't support her case, period. If the court agrees, this could wipe out nearly all of Blake's major claims, everything from sexual harassment to retaliation, and reduce the whole lawsuit to a simple contract dispute between Blake, Inc., and It Ends With Us, LLC. In other words, all the explosive allegations would collapse into something much smaller. Now let's break down Wayfarer's main arguments. California law doesn't apply here. Blake filed harassment and retaliation claims under California's Fair Employment and Housing Act, FEHA. But here's the problem. Blake is a New York resident. The film was shot in New York and New Jersey, and even in her own complaint, she admits the alleged misconduct happened outside California. FEHA has limits. It generally doesn't apply to conduct outside California unless the legislature explicitly says otherwise. And Wayfarer cites cases like Sullivan v. Oracle to back this up. Translation: if everything happened in New York and New Jersey, California law simply doesn't apply. No adverse employment action. Under both FEHA and Title VII, Blake has to show she suffered some kind of tangible negative consequence, like losing a job, being demoted, or having her pay cut. Wayfarer argues she didn't actually allege anything that meets that standard. No causal link to retaliation. Blake claims she was retaliated against after complaining, but Wayfarer points out her timeline doesn't add up. There's no clear connection between her supposed protected activity, the complaints, and the alleged smear campaign she says followed. Courts often require temporal proximity. Basically, retaliation has to happen soon after the complaint for it to make sense. Blake's own timeline is too stretched out. Failure to exhaust administrative remedies. Before you can bring certain harassment or retaliation claims, you have to go through administrative channels first. For example, filing with the EEOC or California's Civil Rights Department. Wayfarer is flat out saying she didn't do this, which means her claims should never have made it into court. Defamation claims are barred. Blake also accused Wayfarer of defamation. Wayfarer argues those claims are barred by privilege and fail to meet the legal standard. Essentially, they're saying even if the statements were made, the law protects them in this context. Civil conspiracy isn't supported. Blake tried to allege there was a conspiracy against her, but Wayfarer says she hasn't pleaded enough specific facts to back that up. Bottom line, Wayfarer's motion systematically attacks every major part of her complaint, piece by piece. And here's the kicker. This isn't even about proving whether Justin or anyone else did or didn't harass Blake. This is about whether her claims are legally valid in the first place. And Wayfarer is arguing that they're not. If the judge agrees, Blake's case shrinks dramatically, maybe even disappears entirely outside of a contract dispute. That's why this judgment on the pleadings is such a powerful move. One of the biggest weaknesses in Blake Lively's case is that she failed to exhaust her administrative remedies, which is required under both Title VII and California's FEHA before a lawsuit can even move forward. Here's why this matters. When she filed her complaint with the California Civil Rights Department, CRD, she never actually included her true employer, It Ends With Us, LLC. Instead, she listed Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and a handful of PR agencies like TAG, Jennifer Abel's group, and Jed Wallace's group. The problem? PR agents aren't her employer, and Wayfarer Studios wasn't technically her employer either. Her employment was through It Ends With Us, LLC, the company created specifically to produce the film. This is critical because under the law, if you don't name your actual employer in the CRD filing, you don't get a right to sue letter against them. And without that letter, you can't legally bring claims of harassment, retaliation, or discrimination in court. Wayfarer and It Ends With Us are seizing on this. Their position is simple. Judge, she didn't even file against her employer. She can't sue us. And here's where things get messy. In the case of Lively versus Wayfarer, Blake has now asked the court to seal her CRD complaint, the very document she already leaked to the New York Times. She's essentially arguing that the document is confidential, even though it's already public. The irony? That same CRD filing proves she never listed It Ends With Us LLC. Jed Wallace even attached that filing in his own case against her in Texas. So the record is crystal clear. She excluded her actual employer. That alone is grounds for dismissal of several of her claims, specifically the 3rd, 4th, 6th, and 7th causes of action. And since more than 300 days have passed since the alleged misconduct, her 1st and 2nd causes of action are also barred. It's game over on multiple fronts. Now let's zoom in on why this distinction between Wayfarer Studios and It Ends With Us LLC matters so much. In Hollywood, it's standard practice to form a separate LLC for each movie. That LLC handles the contract's payroll, taxes, and liabilities. The studio, Wayfarer in this case, may help finance or support the film, but legally the LLC is the employer. Blake's own loan-out agreement reflects this. The signature line clearly shows the deal was between It Ends With Us LLC and Blake Lively Inc., not with Wayfarer Studios. That means her legal claims about harassment and retaliation have to run through the LLC, not Wayfarer. But she didn't include them in her CRD filing, which is a fatal error. Wayfarer and the LLC are now taking two separate but complementary approaches in court. Wayfarer's argument, California law, FEHA, doesn't apply here. Since Blake lives in New York, the movie was shot in New York and New Jersey, and the alleged misconduct didn't happen in California. It Ends With Us LLC's argument. Blake never filed against her actual employer, so she has no right to sue and can't bring these claims in court at all. The goal? Eliminate the harassment, retaliation, and discrimination claims entirely, leaving only a simple contract dispute. And it gets worse for Blake. Even if the judge were generous enough to overlook the procedural mistakes, she still doesn't allege a valid adverse employment action. Here's the legal reality. To prove retaliation under Title VII or FEHA, a plaintiff must show 4 things. They engaged in a protected activity, like filing a complaint. Their employer knew about it. The employer took a materially adverse employment action against them. There's a causal link between the complaint and the retaliation. But Blake never alleges she was fired, demoted, had her pay cut, or was denied future work. Instead, her claims of adverse action boil down to negative publicity. That surfaced in August 2024, more than 15 months. After she first made her complaints in May 2023, courts often require a close timeline between the complaint and the retaliation, but here, the gap is way too wide to suggest causation. In short, she's trying to argue that a smear campaign in the press counts as retaliation. But even if the judge entertained that theory, she still fails to tie it directly to her protected activity. There's no causal chain. To make matters even stranger, Blake admits in her CRD complaint, yes, the same one she's now trying to seal, that her case would require the court to recognize a new form of retaliation that isn't covered by existing law. That's a huge red flag. Courts don't create new forms of retaliation just because a plaintiff wants them to. So what does all this add up to? Wayfarer and It Ends With Us LLC are systematically dismantling her claims. They're telling the judge, she filed against the wrong parties. She didn't exhaust administrative remedies. She can't prove an adverse employment action. She can't prove a causal link. And if the judge agrees with even one of these arguments, Blake's harassment and retaliation claims could be tossed out entirely, leaving her with nothing but a narrow contract dispute. It's a devastating strategic blow, and it explains why she's scrambling to keep parts of her complaint sealed, even though the public has already seen them. The ongoing legal battle surrounding Blake Lively, Justin Baldoni, Wayfarer Studios, and the production company for It Ends With Us has reached a fascinating new stage, one that has the potential to dramatically reshape the case, narrow the issues, and even reduce it from a high-profile harassment and retaliation lawsuit to something much smaller, a straightforward contract dispute. What started as a sweeping lawsuit filled with allegations of sexual harassment, retaliation, hostile work environment, and smear campaigns has, piece by piece, been whittled down under intense legal scrutiny. And now, with Wayfarer and its attorneys filing a motion for judgment on the pleadings, the stakes couldn't be higher. If successful, this motion could essentially gut most of Lively's claims, leaving her with very little to stand on, and leaving the court to address only narrow contract issues rather than explosive harassment claims. So how did we get here? Let's break it down carefully. Because this case is filled with procedural nuance, legal technicalities, and strategic maneuvering that reveal not just the strengths and weaknesses of Lively's lawsuit, but also the methods big studios and production companies use to protect themselves when disputes erupt during or after a film. First, some context. Lively originally filed her lawsuit alleging harassment, retaliation and related claims, naming multiple defendants: Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, and various PR agents and firms such as Tag Group and Jennifer Abel's group, along with Jed Wallace's group. These names might seem random, but in the entertainment industry, they represent a web of creative, financial, and promotional stakeholders tied to a film's production. By suing not only Wayfarer and Baldoni but also PR firms and individuals, Lively tried to paint a picture of a coordinated conspiracy to retaliate against her after she allegedly raised concerns about harassment and working conditions on set. However, as with all employment-related claims, there are strict procedural requirements. Under both Title VII, federal law, and California's Fair Employment and Housing Act, FEHA, before a plaintiff can even file a lawsuit, they must first exhaust administrative remedies. This typically means filing a charge or complaint with an agency like the EEOC for federal claims, or the California Civil Rights Department, CRD, for state claims, naming the correct employer and obtaining a right to sue notice. Here's where the first major issue with Lively's case arises. In her CRD complaint, she didn't actually name her true employer. Instead, she listed Wayfarer Studios and individual defendants, but she left out It Ends With Us LLC, the production company that actually employed her and that signed her actor's loan-out agreement. This omission is not minor. It is fundamental. If the actual employer is not named in the administrative complaint, the plaintiff cannot later sue them in court under employment discrimination laws. This is because the law requires employers to have fair notice and a chance to resolve the dispute at the administrative stage before litigation proceeds. In fact, in her filings, Lively tried to blur the line between Wayfarer Studios and It Ends With Us LLC, suggesting they were one and the same or interchangeable. But legally, that doesn't fly. It Ends With Us LLC is a separate legal entity created specifically to produce the film. This is a common Hollywood practice. Each movie is set up as its own limited liability company to manage finances, contracts, taxes, and importantly, liability. By keeping the production company separate from the studio, the parent company, Wayfarer, insulates itself from direct employment liability. So even though Wayfarer funded the project, It Ends With Us LLC was the actual employer. And since Lively didn't name that entity in her CRD complaint, she technically failed to exhaust administrative remedies against her employer. That failure could be fatal to her FEHA and Title VII claims. Adding to the complexity, Lively has tried to seal her CRD complaint, the very document that could show who she named and what she alleged. This is unusual, especially since parts of that complaint have already been published in outlets like the New York Times. According to filings from Wayfarer's attorneys, Jed Wallace has already attached portions of the CRD complaint in his own filings in Texas, showing that Lively did not include It Ends With Us LLC. So her attempt to seal the document looks less like a privacy move and more like damage control, trying to hide a key procedural flaw in her lawsuit. From there, Wayfarer's motion drills deeper into the claims. They argue that Lively fails to allege any adverse employment action, which is a required element for retaliation and harassment claims under both FEHA and Title VII. Simply put, to prove retaliation, an employee must show that 1. They engaged in a protected activity, such as reporting harassment. 2. The employer was aware of this activity. 3. The employer took a materially adverse employment action against them, like firing, demotion, or pay cuts. And 4. There was a causal connection between the two. But according to Wayfarer, Lively doesn't allege any real adverse employment action at all. She wasn't fired, demoted, denied benefits, or deprived of opportunities. Instead, her claims center on what she calls a smear campaign, negative publicity and PR tactics she believes were designed to damage her reputation. Here's the problem. Courts generally don't treat PR campaigns or bad press as adverse employment actions. Retaliation under employment law is about tangible, job-related consequences: losing a job, losing pay, being denied promotions. Negative media coverage, even if orchestrated by a studio, doesn't neatly fit into that category. Wayfarer points out that by the time this alleged smear campaign began, production had already wrapped, her acting services were complete, and she was no longer under their control as an employee. Thus, they argue there was nothing they could have done to harm her employment because she was no longer actively employed. Wayfarer goes further, dismantling the timeline of her retaliation claims. Lively says she made complaints in May 2023. She alleges that retaliation occurred in August 2024, 15 months later. Courts have consistently held that such long gaps between the protected activity and the alleged retaliation undermine causation. Even a 7 to 10-month gap can be deemed too long to establish a causal link. And even if you start the clock later, say in January 2024, when she claims she renewed her complaints at an all-hands meeting, the alleged retaliation in August still comes 7 months later. That's still too long, and she doesn't show why the gap should still count as retaliation. Wayfarer also challenges her characterization of the PR response. Lively claims the crisis management efforts by Baldoni, Wayfarer, and associated PR firms were retaliatory, designed to smear her. But Wayfarer flips that narrative. They argue the PR moves were defensive, not offensive. According to their filings, internal communications show the team anticipated an onslaught of negative publicity from Lively herself. Criticism of Baldoni as director, disputes over editing and marketing, and general conflict spilling into the public. The PR strategy was, in their view, a response to her actions, not retaliation for her complaints. In fact, the text messages she cites as proof actually show Baldoni and others preparing to defend themselves from what they expected would be her attacks, not punishing her for raising harassment issues. That distinction matters legally. Defending one's reputation is not the same as retaliating against an employee for reporting harassment. One of the most striking examples they highlight is what happened at the film's premiere in August 2024. According to Wayfarer, Lively sidelined Baldoni, instructed cast and crew to unfollow him on social media, refused to appear in photos with him, and banished him and his family to the basement during the premiere until she finished her appearances. This, they argue, triggered a wave of speculation and negative press, which then necessitated a PR response. From their perspective, the alleged smear campaign wasn't retaliation at all. It was damage control after she herself created negative optics. And this is where Wayfarer's argument becomes particularly compelling. Even if the PR campaign was aggressive, even if it included pushing back on Lively's narrative, that doesn't automatically make it retaliatory under the law. It has to be connected directly to her protected activity, her harassment complaints. And here, the timeline, the context, and the evidence don't support that link. Courts require a causal connection, not just correlation. Wayfarer says she fails to establish that link, meaning her retaliation claims collapse. From there, the motion tackles her defamation claims. These, they argue, are barred by litigation privilege. In both California and New York, statements made in connection with ongoing litigation, including out-of-court statements by attorneys, are protected. Just as Lively's public CRD complaint was privileged, so too are the responses by Wayfarer's counsel. This shields defendants from defamation liability when discussing ongoing cases. Without a viable defamation claim, her argument that PR agents conspired to defame her also falls apart. Next comes the civil conspiracy claim.